Justice is a cross-party law reform and human rights organisation working to strengthen the justice system. It's the UK section of the International Commission of Jurists, and its vision is of fair, accessible and efficient legal processes in which the individual's rights are protected and which reflect the UK's international reputation for upholding and promoting the rule of law. So, as you say, it established a working party, which I was privileged to chair. And our working party was made up of professionals across the family justice system, judges, lawyers, magistrates, as well as legal academics, to explore the problems facing families who come to the family courts in child arrangements proceedings and to consider how to improve the system. And we did consult very widely with professionals from across all the disciplines working with families in this sector, as well as talking to experts in other jurisdictions. So we do draw quite a lot on good practice elsewhere. And importantly, we also talk to adults and children who've been through the family justice system themselves. Now, we were, of course, aware of the huge amount of work that's already been done in this field. And what we wanted to do was to build on that by adopting an explicit access to justice perspective, which recognised that while disputes originate in relationship problems, and most are resolved outside of court, there will always be a proportion of cases that will and should be brought to the courts. And so we wanted to give attention to what goes on in the courts as well as to what goes on outside it. And if we move on to the next slide, just to explain that in the context of child arrangements, we took access to justice to mean access to safe and sustainable child arrangements as a result of a fair and accessible process in which the child's welfare is the paramount consideration as required by Section 1 of the Children Act, that necessary information relevant to the child's welfare is available so that the decision that's reached is more likely to be realistic and sustainable, and that all those who wish to, including children, can effectively and meaningfully participate. And it's really how to give effect to that last goal that lies at the heart of our detailed recommendations. Just to explain that we identified 3 key principles, and those underpinned the goals that I've just set out and also formed the rationale for the kinds of recommendations that we came up with. The first principle is that the rule of law requires access to forms of dispute resolution, including access to the courts. And it can't be described any better than it was put by the late Lord Bingham, the Lord Chief Justice and Senior Law Lord, when he wrote his book on the rule of law in 2010. And I've put the quote there on the screen. It's possible for perfectly reasonable and well-motivated people to hold very different views, including about the upbringing of their children following their parents' separation. And then, as he said, the need is for a binding decision because it's not in the interests of those involved in the dispute or society as a whole for victory to go to the stronger. So that was the first principle. The second was that the family justice system should be designed around the needs of families, not the expertise of legal professionals. Because in a system where not all litigants can be diverted to non-court resolution, but most have no access to legal aid or representation, the system can't simply sit back and assume that litigants in person can do what a legal professional has been trained to do over many years. There needs to be a more proactive approach on the part of the system. And finally, the child's perspective has to be at the heart of every stage of dispute resolution in the family justice system. It's nearly 40 years since Baroness Butler-Sloss famously noted in the Cleveland Child Abuse Inquiry that the child is a person and not an object of concern. And it's more than 30 years since this country ratified the UN Convention on the Rights of the Child. And yet the Nuffield Family Justice Observatory has found that fewer than half of children who are the subjects of private law proceedings in court are given the opportunity to express their wishes and feelings. Our working party believed that it's high time for the system to recognise and give effect to these children's rights. So I'll now pass over to Ellen to take you through our recommendations. Thanks.
Thank you, Gillian. Yes, so my name is Ellen Lefley, and I was the lead lawyer who works for Justice, who worked with Gillian on this report on improving access to justice for separating families. Thank you very much to this APPG for hearing us in this evidence session. And I'm now going to speak to you about the recommendations that were made by that Justice Working Party that were underpinned by the principles and the access to justice definition that Professor Douglas has laid out. Before I do, the evidence base Professor Douglas has gestured towards, it involved over 100 consultations, including those with lived experience, those nationally and internationally with experience of family justice systems and processes, as well as over 200 reports, studies, academic texts and cases, all of which are well referenced within the report itself. But in our findings, the Working Party found a disaggregated landscape of services, processes, and professionals within the family justice system in England and Wales, in which families are floundering at what we've already heard from Ben Hine is an acutely difficult time. And the Working Party found that opportunities to help particularly marginalised, disadvantaged, and at-risk people were being missed and their voices not heard. And those voices include those of children. So in terms of how the family justice system can be part of the solution to these separating families and not part of the problem, I'm going to lay out our recommendations, which I am going to go into a little bit of detail about. So before I do, and before I go on to that slide, I will just set out 3 themes. The first being to help families earlier. The second being to identify and respond to risk better, and the third being to listen to children. So firstly, I'm going to show you 2 slides. The first is with respect to the family justice system outside of the court, beyond court. And the Justice Working Party started here because the solution, of course, does not only lie in court, and the majority of families do not go to court. But the solution for families, as you can see here within this circular graphic, which I will explain, is not about forcing all families into one linear process. As we've already heard, not one size fits all, and different families have different complex needs. And the solution, the Working Party saw it, fell in creating a holistic system that could respond to the multiple needs of the family, keeping the family at the centre. So this graphic attempts to show some of our key recommendations of how families can find access to justice and resolution outside of court. The first being, as you can see, starting from the centre, the existence of an online information platform. That is not a new recommendation that Justice has made. That is a recommendation which has existed for some time. There currently exist too many distinct sources of information, and the authority and reliability is not currently clear. The second is this circle of coordinated services, because the Working Party considered that multiple services are often needed, both legal and non-legal, by families upon separation and ongoing, and that it was coordination between those services that was really missing. You can see that a selection are listed within that diagram. They include GP and health services, counselling, as well as legal services, one of which is early legal advice at around the 1 o'clock mark. That is not something which is consistently available. Publicly funded early legal advice is not something which is consistently available. And that was another of the key recommendations of the Working Party, that publicly funded early legal advice should be available to these families so they can get a handle on what the law says about their separation, what the courts can and can't do, what their options are, and getting some advice which is tailored to their situation, not just generic legal information. You can see the red ring there, which seeks to present a stage between the family and any of these services or sites of support, is what we've named a common screening tool. And this was another of the key recommendations from the Justice Working Group, which is systematic universal risk screening anywhere that the family presents to ask for help. Now, this was in response to looking at various places that a family will go to seek support and help, legal and non-legal, in the community. And what the Justice Working Party found, which is a completely inconsistent response to risk. Some professionals seeking to screen for risk, some not. And when they do screen for risk, no consistent risk screening tool being used. Now, I pause here just to make sure that we are clear that when we talk about risk screening, we're not talking about full risk assessment. There is a clear difference between risk screening and risk assessment, which is simply that screening seeks to identify whether full risk assessment is needed. It also seeks to identify whether some additional support and expertise would be helpful. And we've heard about public separating families being a public health issue. And systematic and universal risk screening is part of seeing this as a public health issue. It's about whether someone is a GP or a family separation counsellor or a lawyer or a mediator. They see as part of their intake of a new client I'm sorry, can you hear me?
Yeah.
Oh, thank you. Sorry, my screen went blank there, but you're back. Where was I? Sorry, where did you last?
We hardly missed anything, Ellen.
Yeah, you were talking about the intake professionals, what they have to do.
You were on to systematic universal risk screening and what it really meant.
So the systematic completion of a risk screening tool, which would identify if a fuller risk assessment was necessary. Finally, with respect to the wider system beyond court, we sought to add two additional key recommendations. The first was that while we supported mediation, mediation was not the only non-court dispute resolution option for families. And we recommended that more options be available to families that aren't limited by their financial means. And finally, the recommendation which had relevance both in court and out of court was child participation. The Working Party's work was underpinned, as Professor Douglas has already said, by the child's right to participate. And that was underpinned by Article 12 of the United Nations Convention on the Rights of the Child. And that Article 12 is clear that the child's right to be heard is not limited to judicial processes. And we recommended a presumption that children be enabled to participate, regardless of whether their parents seek resolution of their child arrangements problems in or outside of court. I'm just going to move on to the next slide, which is on the whole system, including court. I have an eye on the time. So court is one of these coordinated services. And what we recommended was that the court process instead of being an adversarial system designed for lawyers, instead be a system which is redesigned for families, and that it approach its role with those families through an initial investigation and a problem-solving approach with a court team. That would identify the best way forward for the family, which could include referrals to services outside of court. Should it continue in court, it would do so with enhanced case management information, because the court team will have spoken to the family and the child and obtained an increased amount of information than is currently the case. It could identify another resolution process like mediation, which could assist the family better. So the family could have a route out of court. If court was the right resolution process, then we recommended a bespoke process. So not one which was one size fits all and a certain number of hearings, but one that was tailored to the needs of the family. And finally, the Working Party recommended that final orders be pending review. And this was to ensure that the outcomes, I know this particular evidence session is about improving outcomes for children, that was to make sure that the court had some oversight of whether the outcomes were in fact doing as intended, which is to be working in the best interests of the child, and to make sure that orders were not made with no idea as to whether the orders were actually working for the child on the ground. Other processes which would be continuous in court were two, and they were focused on participation. The first, a case progression officer role, and this would be to assist litigants in person before, after, and between hearings to ensure that they could effectively participate in court processes, following what we heard was real marginalization and disadvantage by those without lawyers. And then also a continuous duty to ensure the child could participate. I could do a whole session on children's participation, but I will just briefly list them. So making sure there was someone the child could ask for information and updates, ensuring that children who wanted to could be fully heard, the opportunity to meet the judges or meet the judge or the justices where appropriate, and the opportunity for feedback to hear what had happened and why. We then made various recommendations for improved resources, which I won't go into in detail. We did not choose to argue for any unrealistic resource increases, such as rewinding to pre-legal aid cuts, but there were a limited number of improved resources that we sought. Implementation, those here know about the Pathfinder Court, so I won't go to those in any detail. They're not a direct implementation project from the Justice Report. They were happening anyway, but myself and various Working Party members contributed to the advisory groups informing the Pathfinders. And the investigative approach, fewer hearings, hearing the child's voice earlier, all of those can be seen to be common priorities between ours. There is also going to be an early legal advice pilot, and the Ministry of Justice has committed to developing an online information portal. And work is ongoing to draw attention to the need for systematic universal risk screening, drawing attention to an Australian model. I'll stop there because I know I'm out of time, but I would just flag that I think the next real challenge is child participation point, and making sure that there is a presumption of that throughout the family justice system, both in court and out of court. Thank you for your time.
Thank you so much, Ellen. I do wish we'd come across you some months ago, because we seem to have reinvented the wheel. What's really great is that we've reinvented roughly the same wheel. So much of what we have in our draft report reflects that. Now, I'm aware that we are running a little bit behind the time. I was just wondering, Sir Andrew, whether you can give us another 5 minutes, or whether we need to ask you to speak straight away.
Well, we're finishing at 7, so I'm happy to cut it short if that's helpful.
Well, it would be a matter of finishing a little after 7.
Sorry, I thought
Would it be all right if we take some questions for Ellen now?
Yes, certainly. Yeah.
And you be a little bit late and finish a bit after 7. Great. Okay. Any questions for? We've got a hand from Sam Morphy.
Hi. Thanks, Gillian and Ellen. That's really interesting and enjoy that and a lot of the recommendations. I know that Pathfinders probably is actually in line with those things. I guess my one thing is around the child's participation, which in theory, I know you said it's a whole separate session, so I don't want to go on it because I know obviously Sir Andrew's obviously waiting to speak as well. But I guess, has any analysis been done of the risk to children of being, and especially at a younger age, almost being, there's, because the risk of them being under undue influence or under some form of almost being put in a position where their voice becomes so prevalent that they're almost having to act like adults rather than children, with adults making decisions for them. I mean, it's a whole new area, but was that looked at as part of the project?
Yeah, thanks, Sam. Absolutely. I think the presumption of participation is about a presumption of safe participation, and participation, if it's going to be done, has to be done well. So it's very much not a recommendation that participation should be enforced at all costs. Firstly, the opportunity needs to be given, and whether it's not, the presumption would be able to be rebutted if it wouldn't be in the child's interest. And there are detailed considerations actually in the United Nations Committee on the Rights of the Child. Their general comment on Article 12 goes into detail about how child participation as an activity needs, part of its rights compliance is that it is done well and by a professional, and that it's done safely.
Michael, could I answer that point too?
Yes, please do, and then we'll go on to Philip Marcus.
Yeah. Okay, I just wanted to say, I wanted to ask a question, but I particularly wanted to say that I very often saw children, and I remember one girl of about 12 who told a story to the welfare officer and told me a completely different story. And I said, why have you told me this? And she said, well, you're the person who matters, aren't you? And I said what I thought people wanted to hear to the welfare officer, which I thought was very interesting. And I had the impression that when they saw the judge, the many children I saw actually thought this was the moment that they could say what they really thought. At least they seemed to be able to me. But I'm just concerned about publicity and having the press in as to the way in which justice has looked at children participating.
Shall I have a go at that? I mean, we weren't actually envisaging that children would be in the courtroom very much.
Right.
If the idea is really that there will be someone in the court team who is really the child's link. There will be occasions when the child wishes to see the judge, like you explain. But generally speaking, we're not by any means suggesting that children are called into court.
I'm relieved to hear it.
Okay, Philip Marcus, quickly.
Very briefly, I also saw lots and lots of children in my chambers, but that was only if they asked to come, or I found it essential. We always had a social worker present. We now have a very sophisticated scheme in Israel where children are seen by qualified social workers who are specially trained, and what the children say is not brought to the attention of the parents. There is a general report, and I can describe that scheme. I'm also most concerned that when you're considering risk, you should be considering the risk of psychological harm from not seeing a parent as much as the physical and sexual risk. There is new literature about psychological maltreatment, and the absence of contact between a child and a parent can cause the most terrible, devastating psychological harm. So risk ought to include all three types: physical, sexual, and psychological harm.
Just to flag, there are some interesting points that I won't go into detail now on, that there are some, I think, Canadian models that have a level of confidentiality in what the child discloses, just to flag that.